Good afternoon, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. And before my entire week of severe storms start and the power goes out inevitably again, we're going to go ahead and get back to our Section 8 HUD series. We're going to be covering today, in particular, the eligibility criteria in regards to non-citizens and answer that question that for some reason there are way too many people in this country who don't know in regards to whether we fund illegals through Section 8 or not. The fact people don't know the answer to this question automatically and are just willing to believe whatever comes spewed out of a Republican mouth is giving me more than just a few migraines. So, we're going to be going again and taking care of that, but first, folks, any of the documentation we use as we go throughout the HUD Section 8 series, you're going to find links right there in the description box, just in case you want to double check the sources or go ahead and do a deep dive in the topic yourself. Alright? Trigger warnings, this channel is marked not for kids for a reason. We do use profanity, and we speak on dark subjects like the Judge Rotenberg Educational Center. So if you have a child that is 16 and younger and they are watching this, parental supervision is advised. Political trigger warning. If you are gung-ho MAGA or you are gung-ho on the left, I am neither of these things and will more than likely at some point say something that's probably going to offend you. If you are unable to handle that like an adult and debate on the facts and instead engage in ad hominem attacks, declaring everyone has Trump derangement syndrome, spare me. Seriously. Anything of that nature will be removed, and the individual who placed the comment will be blocked from the channel. Nobody has time for that. Alright? Okay. So we're going into this documentation here from HUD.gov, which is an actual government website. So in case you're wondering, so you said that it's the left-wing media? It is literally a federal government website. Please spare me. For all, in the name of God and all that's holy, spare me. Alright, eligibility factors for admission. Family eligibility requirements. The household must meet HUD's definition of a family, which is provided in Section 3, Family Eligibility Requirements. Income limits. The household's annual income must not exceed applicable income limit as established by the HUD in the jurisdiction where the family leases a unit. We already went over that information in a previous video in this series. This requirement applies at the time of admission and is reevaluated at the time of reexamination. Section 4, Income Limits, further describes this requirement. Citizenship or eligible immigration status. Each applicant in the household must have citizenship or eligible immigration status with supporting documentation. Citizenship status only needs to be verified at the time of admission for each family member. Information on how to verify citizenship and eligible immigration status and calculate assistance for families that include ineligible non-citizens is provided in Section 5, Citizenship Status. So, I have that pulled up right here because I wanted it to be quick. We have storms on the way and I didn't want to waste time. So, citizenship status. Eligibility for federal assistance, such as the PH program, is limited to U.S. citizens and non-citizens who have eligible immigration status. Families which all members are U.S. citizens or have eligible immigration status are eligible for housing assistance. So if you remember, we went over that yesterday and in a few other of the series, what type of documentation is generally required for you to benefit from services. It's the exact same thing for HUD in Section 8. Families in which at least one member is a U.S. citizen or has eligible immigration status may be eligible for partial or prorated assistance. A family in which some family members are eligible immigration status and some do not contend eligible immigration status is referred to as a mixed family. Family members whose eligible immigration status is pending are considered ineligible for assistance until their immigration status is fully authorized. We're going to read that again for the MAGA people in the back. Family members whose eligible immigration status is pending are considered ineligible for assistance until their immigration status is fully authorized by the U.S. Citizenship and Immigration Services. In other words, if you are an illegal alien, you are not going to be able to receive the benefit of help with rent by means of HUD in Section 8. Period. In order to qualify for as a non-citizen, if you are legal, you have to have the proper paperwork to show that status, or they're not helping you. So once again, this bizarre idea that somehow our tax dollars are subsidizing individuals who are illegal to things like Section 8 is batshit insane. And I've heard the argument, but the states, let me make you aware of something in regards to the states. States have their own locally funded programs that are not through Medicaid, that they fund through local dollars, that state may determine to help out a few illegals in bad straits. That is correct. What is incorrect is the idea that that is somehow Medicaid. No, it's not. As a matter of fact, a lot of the programs we are talking about here have absolutely no connection to Medicaid, HUD, SNAP, any of it. It's an entirely separate state program funded by the state. So what does that mean? Because they're insisting that somehow these illegals are getting our taxable dollars. It's because Trump has them convinced that through the state part of Medicaid is funding those programs, and therefore federal Dude doesn't even know how Medicaid funding actually works, let alone the fact that you do not get access unless you are either a legal citizen or have legal immigration status and the proper documentation to back it up. If you do not have those things, you do not get access to those benefit programs. Some states have programs that help assist and subsidize people who are illegal aliens who are in dire straits. But those programs are state-run, state-funded, and not a single dime of federal money is being funneled into those programs. Those come from state taxes. Okay? So that means it's not Medicaid. It's a separate program. So, federal tax dollars are not subsidizing jack shit. It's a lie. But the state Medicaid is doing the same thing federal Medicaid is doing. Separately run state programs run off of state taxes, not federal. Can somebody please, that's a forensic accountant, go to the White House and start knocking some sense into these people? For the love of God and all that's holy, send a whole team of forensic accountants If they are that paranoid about fraud, let them put together a super team of some of the best forensic accountants in the country and just let them audit everything. People who actually know how to do their job. Because very obviously we've got more than just a few GOP who have no idea how these programs are funded or what they're funding, how much is state, how much is federal, what is Medicaid, what isn't Medicaid. Please, for the love of God. Sorry, but my God, it's driving me nuts. Let me go ahead and continue here. Once these family members receive their immigration status, the family's financial assistance will be redetermined accordingly. Mixed families receive prorated assistance based on the percentage of family members who qualify for assistance. An individual who is not a U.S. citizen or national who is a resident of the U.S. and has any of the following immigration statuses is eligible for assistance. Here it is, folks, the black and white. A non-citizen lawfully admitted for permanent residence as an immigrant as defined by Section 1101A15 and 20 of Title 8, excluding among others alien visitors, tourists, diplomats, and students who enter the United States temporarily with no intention of abandoning their residence in a foreign country, lawful permanent residents or LPRs. A non-citizen who entered the United States prior to June 30th, 1948 or subsequent date as is enacted by law has continuously maintained his or her residence in the United States since then and is not ineligible for citizenship but who is deemed to be lawfully admitted for permanent residence as a result of an exercise in discretion by the Attorney General pursuant to Section 1259 of Title 8. A non-citizen who is lawfully present in the United States pursuant to an admission under Section 1157 of Title 8 or pursuant to granting of asylum, which has not been terminated under Section 1158 of Title 8, refugees and asylees as long as their asylum has not been terminated. A non-citizen who is lawfully present in the United States as a result of an exercise of discretion by the Attorney General for immigrant reasons or reasons deemed strictly in the public interest pursuant to Section 1182D5 of Title 8, a non-citizen paroled into the U.S. for a period of at least 1 year. A non-citizen who is lawfully present in the United States as a result of the Attorney General's withholding deportation pursuant to Section 1231B3 of Title 8, a non-citizen withholding removal under 8 U.S.C. 1231. A non-citizen lawfully admitted for temporary or permanent residence under Section 1255A of Title 8. A non-citizen who is lawfully residing in the United States and its territories and possessions under the government of the Marshall Islands, the Federated States of Micronesia, 48 U.S.C. 1901 note, and Palu, 48 U.S.C. 1931 note, while the applicable section is in effect, provided that within Guam any such alien shall not be entitled to a preference in receiving assistance under this act over any United States citizen or national resident therein who is otherwise eligible for such assistance. A non-citizen who is a human trafficking victim and certain family members who have a certification later for the Department of Health and Human Services, including T1 non-immigrants and continued present recipients, are non-citizen minors who have received a child eligibility letter from the Department of Health and Human Services or are granted derivative T non-immigrant status by USCIS T2 through T6 non-immigrant status, or a non-citizen who is a VAWA self-petitioner under 8 USC 1101A51, 8 USC 1641, 62 Fed Reg 61344, 61367, November the 17th, 1997. Non-citizen students, even those eligible with eligible immigration status, are not eligible to receive housing assistance. When a non-citizen student is accompanied by a non-citizen spouse and or non-citizen minor children, those family members are also ineligible for assistance. However, citizen spouses and the children of citizen spouse and non-citizen student are eligible for assistance. Assistance would be prorated if a household includes a non-citizen student and citizen spouse and or citizen children. A non-citizen student is a bona fide student who is pursuing a course of study in this country, has a residence in another country outside of the United States, and that person has no intention of abandoning, and is admitted to this country temporarily solely for the purpose of studying. Now, documentation of citizenship immigration status. We're going to read through this here real quick. Each eligible member, or the parent guardian for the family members under the age of 18, must sign a declaration of their status. Eligible non-citizens must also provide supporting documentation, as all of that we just went over a moment ago. Family members who do not sign a declaration of their status or provide the required supporting documentation will be considered ineligible non-citizens. Documentation must be submitted no later than the date of eligibility determination. Once documents have been submitted and verified for an individual, citizenship documentation for that individual will not need to be collected again. Household members who do not provide required proof of citizenship or eligible immigration status will be considered ineligible non-citizens. PHA options. PHAs are permitted but not required to adopt policies requiring additional documentation to verify U.S. citizenship. If the PHA's policy is to require verification of citizenship, the PHA's plan must clearly state this policy. The policy must be applied consistently to all applicants and in a non-discriminatory manner. And then we have the extensions. So we'll go ahead and go over this here real quick. If the family submits declaration of eligible immigration status and certifies that the family needs more time because of the required evidence is temporarily unavailable, the PHA must provide an extension of up to 30 days to submit evidence of eligible status. To obtain an extension, the family must also certify that prompt and diligent efforts will be taken to obtain the evidence, including proof that you are in the process. Upon determining if the extension request meets the requirements, the PHA must inform the family in writing whether their request for a time extension has either granted or denied. If granted, the notice must state the specific period of the extension. If the extension request is denied, the notice must explain the reasons for the denial. Alright, verification of eligible immigration status. The PHA is required to verify eligible immigration status through the U.S. Citizenship and Immigration Services. While the PHA may not admit any individual prior to receiving the required documentation described in Exhibit 1, the PHA may elect to provide assistance to the family prior to completing the verification process. Primary verification method. The PHA must conduct primary verification of eligible immigration status through the CIS automated system, Systematic Alien Verification for Entitlements. System login instructions is right there. That's mainly for the handbook of people who work for HUD and handle the paperwork. Secondary verification method. If the primary verification system does not confirm eligible immigration status, or if the primary verification system verifies immigration status that is ineligible for assistance under Section 214 covered program, the PHA must attempt secondary verification. As of 2018, the SAVE system verification process is paperless. The PHA must submit a request for secondary verification to CIS within 10 days of receiving results of primary verification. To request secondary verification, the PHA will forward photocopies of original required documents with the Form G845S document verification request or some other form specified by CIS. If secondary verification fails, the PHA must notify the family in accordance with notification requirements described in subsections 5.4.1 and 9.2 of this chapters. Now, that gives you the appeals process, of course, and then they get into prorating. But I believe, honestly, it makes it quite clear. Just like the other programs we've been taking a look at this week. If you are a non-citizen, if you are here in the United States, and you are an illegal who cannot provide evidence of your legal immigration status, you are not getting any services through HUD Section 8. If you're an illegal alien, HUD will not help you cover your rent. If you do not have proper documentation, nothing happens. You know what that means, folks? That means HUD, that is funded through our federal tax dollars as well as state, is not